some agreement are forwarded to the public protector, and she forwards things to us. We forward things to the IEC, they forward things to us, we forward things to the Commission for Gender Equality. So this is a case that is being dealt with by the Commission for Gender Equality, where we can intervene, as in the case of Caster Semenya. We have intervened and we are intervening. We are in the European Court to deal with the issues of gender, but mainly that is the mandate that is in the hands of the CGE. And with regard to the visibility of the Human Rights Commission, in our view and our assessment, the Commission is quite visible. We will then have to look at the suggestion that it is not accessible. It hadn't come to our attention that it's not accessible. In fact, I think the CEO will confirm that we have dealt with actually in the greater number of complaints than previously. The media is aware of us. We get interviewed on an ongoing basis, even in vernacular radios like Xhosa speaking, Zulu speaking, Ndebele speaking, Sotho speaking. We are all there, and these, some of them are regional radios, and we are visible to the communities there. There may, of course, be people who do not know about the Commission, but I think the Commission is doing its best to be vocal and visible. The issue of the fourth industrial revolution, may I leave it to the CEO? The issue of the government departments having diverted funds towards COVID-19, and then the results, the transgression of rights of individuals. Well, Honorable Ngula may have a point in this regard, simply because there have been debates and discussions within the Commission as to the extent to which rights have been violated, and to the extent to which those violations are in transgression of Section 36 of the Constitution. It's something that is debatable. We in the Commission have seriously debated the ban on alcohol, the ban on cigarettes and what have you, but got to a particular conclusion about whether or not to take these matters forward. But departments such as social DSD, COCTA, and others know that where we found that there were violations, of course, we go to them, we write, and we have had many things changed because of our interventions there. My sense is that perhaps it's a matter of degree rather than whether the Commission is doing something and whether the Commission is visible. We could be visible with more resources if we can have. Commissioner Nissen and the CEO will deal with the issue of OPCAT and the steps to mitigate COVID-19. The Vaal River pollution matter, I think Honorable Breitenbach would remember that Minister Sisulu immediately responded and promised action that she would be taking. The Gauteng Provincial Office is following up, is monitoring this and following up on it. It may be too soon to say, to make a call on it, but it is something that, yes, the Commission is monitoring. Chairperson, the issue of the IMC, we would be very pleased if we could get assistance in that regard, because we have asked that we appear before the IMC. We were called to appear before the technical committee of the IMC, and then promised that the actual meeting with the IMC would take place. How to unblock that, I do not know. I do not know. And then the CEO will deal with issues of space and how much savings, as well as the issue of POPIA. Finally, Chairperson, thank you very much for the point about the broadness of our targets. We note it, and we're certainly going to make sure that we revise our targets, and that for the future we peg them accordingly. And then the internal audit, the CEO will answer. Thank you very much. Perhaps Commissioner Gam could come in, followed by Commissioner Nissen, and then the CEO will finalize.
Yes, thank you very much, Chairperson of the Portfolio Committee and Chairperson of the South African Human Rights Commission. In response to Honourable Nieuwenhoven's question about monitoring of schools, as the Chair have indicated, we are indeed monitoring schools, including farm schools. We don't have the capacity to monitor all of these schools, but we do that to the extent that that is possible. During COVID-19, Commissioner Nissen will tell you that we have formed a Section 11 committee for purposes of monitoring. And in that process, we involve civil society organizations who were not able to do work themselves, but under the auspices of that Section 11 committee. And we very specifically continued to monitor schools even during the entire period of COVID-19 and the lockdown and so forth. As far as the specific examples mentioned by Honourable Nieuwenhoven are concerned, of schools with inadequate infrastructure, I would ask her to please bring that to my attention. We have regular contact when she has issues that she wants to bring to the Human Rights Commission attention. So please, if she can do that, that is absolutely unacceptable in terms of the national norms and standards for school infrastructure. It is quite clear what measures need to be met by the department, and we are absolutely enforcing those infrastructure norms and standards from our side. So if the specific examples can be brought to my attention, then I can assure you that we will deal with those issues. Then, as far as the visits to schools for children who are deaf is concerned, I will certainly also, from the education focus area side, liaise with Commissioner Malachi. We can bring these visits and we can look into this particular issue pertaining to the wearing of masks and make a determination as far as that is concerned and engage with the relevant education departments. Then on the matter of water and sanitation in the school context, the Commission has done a lot of work already in this regard, engaging the National Department of Basic Education, but also engaging the MECs for education. According to the National Department, all schools in the country, and that is what they have been informed by the provinces, that all schools in the country do have at least a water tank and at least a temporary sanitation facilities that is adequate. We have found that that is actually not really the case. And somewhere there is a communication gap, or the correct information is not provided to the National Department and the DG there. And therefore, I have engaged all the MECs for education in the provinces, asking them for specific data and details as far as water and sanitation is concerned. Unfortunately, I have to report to the Portfolio Committee that there are some of these MECs who are simply not responsive. Some of them have delayed the provision of that information drastically. And in other cases, in the case of two provinces, the Eastern Cape and the Free State, we simply did not receive a response. So the Commission has therefore decided to subpoena those two MECs for that information. I'm also writing another letter today to all the MECs asking them for updated information in this regard. And the Commission will have no choice but to subpoena MECs that do not respond this time around in time. The first request for this information has already been sent to MECs last year, August. And, as I indicated, two of them haven't even responded up to this particular date. But we are determined to deal with this matter of water and sanitation at schools. All schools should at least have water tanks and should at least have temporary sanitation facilities, especially during the COVID period of time. There was also the question about protest action and municipalities. The Commission has decided that we will now start focusing very specifically on municipalities that are dysfunctional, that are not providing the services required, and we will start intervening in these municipalities. We are already intervening in a specific municipality and taking the municipality to court due to its non-responsiveness and the fact that they are not dealing with basic service delivery issues. On the visibility issue, I think the CEO also have the specific statistics as to how visible the Commission has become, and maybe you should provide that to us. Our visibility has increased quite substantially over the last couple of years. And just on the fourth industrial revolution issue, the CEO will deal with that, but from my side, the Commission has adapted quite dramatically as far as that is concerned. We are having these kinds of virtual meetings with people around the world. I was involved in a conference with people from all over Africa not long ago. We are consulting with our lawyers pertaining to the Caster Semenya side case. Some of our lawyers who are pro bono and based in the UK, professors from Oxford and so on. So I think the Commission has adapted quite dramatically as far as that is concerned. Even this national school moot court competition will this year be a virtual competition, and data will be made available to learners to ensure that they can participate. And I think the fact that we have also taken the step of decreasing our office space is a further indication of the fact that the Commission has immediately adapted to the new environment. But the CEO can also, deal with that matter more specifically. I remember I think it was last year or the year before, we already had a conference or a workshop on the fourth industrial revolution, its impact on human rights and on the Human Rights Commission as such. Then just from as far as the National Disaster Act is concerned, violations of rights and so on, as the chair pointed out, the Commission has constantly asked ourselves the question whether regulations from government in this regard, whether these regulations were indeed reasonable and justifiable in terms of Section 36 of the Act. In some cases, whilst we were very specifically considering taking some of these regulations to court ourselves, other civil society institutions did that, so it was not necessary for us to do so. But specifically in relation to the matter of the opening of schools and schools staying open, the Commission has intervened very specifically. In one case, we have differed with government quite substantially when the opening of schools was delayed, and we made our point quite clearly that in our view, it is not reasonable and justifiable under those circumstances to delay the opening of schools. We have engaged in this regard very strongly with the DBE, and interestingly enough, in most instances, we and DBE actually agreed that schools should be first to open and last to close. How much savings? I'll leave that matter to the CEO. It is CEO. It's quite clear from page 32 of our submission, the substantial saving that we are making. And I think, last of all, it is indeed, in my view, an example we are also setting for others, that we were willing to decrease our office space and to adjust as far as that is concerned in order to save money and to adapt to the COVID-19 situation. Thank you very much, Chairperson.
Chair, I don't know if Commissioner Nissen is here, otherwise I can proceed. Hello.
Proceed, Advocate Panyan.
Okay, thank you, Chair. Can I then start with the issue of 4IR? That it has been mentioned that the Human Rights Commission did organize a conference last year, March, on 4IR and its impact on human rights together with the HSRC. And we have just published a book together with HSRC, which came 2 weeks ago, on how bodies like us could respond to the challenges of 4IR in terms of human rights. But also, as my commissioners have pointed out, we've also made adjustments as a commission as to how to use 4IR in order to effect our work. And therefore, when COVID-19 came, we then took a decision to make those changes last year, April, after the conference in March. So what we have done, for example, Chair, is that we've given all our staff members laptops and data to be able to work from home. Most of our engagements are now through these digital platforms. If you recall, last year, our 25th anniversary in October, as well as in December, where it was mainly digital, and therefore able to reach out to more people. In March this year, our conference on corruption and human rights, which included bodies like the AG, IPID, Public Service Commission, everybody else, was 100% digital. So we're basically moving into that direction. Of course, our problems with this approach, Chair, is that some people will not be able to have access to these platforms due to issues of internet and data. And therefore, also thinking of pushing that we must actually push hard to make internet a human right, access to internet a human right. And we raised these issues last year with government around issues of education, that the lack of internet or access to internet was really creating inequalities in our countries between rich and poor learners. That's an issue which we'll still have to deal with as we go around issues of monitoring education in schools, because clearly, as COVID-19 continues, we will have to rely more on these platforms and therefore a greater usage of 4IR. We have an MOU with the HSRC to look into how we can further advance this work around 4IR, because that definitely is the future. So we can assure you that this will remain one of our major concerns. So even the reduction of the office space was also take into account that where to a large extent, will now allow our staff members and commissioners to be able to work from home and also in the office. And so in that regard, Chair, the reduction, the savings from our rentals, I'm told it's about 7 million rands. We've reduced from 7,000 square meters to 2,005 square meters. We've largely made offices open plan so that people can just walk in and out. And of course, much of the savings will be much more realizable next year, because now we have to buy furniture and mix, and other necessary changes. But certainly, it is a huge drop in that regard, and I think we must be commended, despite, of course, all the pains of moving from offices to open plan. We'll need to address that as well in the commission as to how do we deal with this. And then, and then on the issues which have also been raised. Sorry, I've just missed up my pages here. Damn. Ooh. Sorry, I lost my, mixed up my pages. Let me try and remember what was said. Okay, Then on the issue of Papaya, we have an arrangement with information regulator. We've actually moved in the same building with them, so that our neighbors, even in this new building. So we are meeting, we have signed an agreement on transition, and therefore we'll work hard to make sure that, we as a commission, after the IR, the second body which leads by example as far as, adhering to Papaya. So we'll do our best to make sure that we do adhere to this despite all the other challenges which we have. Then, as far as the audit matters are concerned, Chair, that still remains a concern. But we have a new audit committee, and we have a new CFO. And I don't want to make an excuse, Chair, that for the past 2 years we've been using a level 12 as an acting CFO due to the problems we had with our previous CFO. Now at least we have gone back now to appoint a CA at level 14 who will help us to deal with these issues. And we do appreciate also the role which has been played by our acting CFO over the past 2 years, even at that level, just to hold the fort. So we will definitely look into these issues as much as we can. And we promise we'll do much better. We've had meetings to make clear to colleagues that, we need to get a clean audit, not just an unqualified audit, but a clean audit going forward. We'll see what we can do, Chair. Now, on the issues of visibility, Chair, again, the issue is, according to whose standards? I would like to believe that the Human Rights Commission over the past 3 years is one of the most visible Chapter 9 institutions. In terms of our media coverage, we're in the media almost every week. And last year, when we reported to Parliament, to the Portfolio Committee, our media coverage was worth over 400 million rands. This year, when we submit our reports, there might be a decline due to COVID-19, but it's still very, very high. We do acknowledge, Chair, however, that, the reach to rural areas and, other marginalized areas is still a concern for us, which we have to address. And that's why, for example, during COVID-19, we had these monitors who were working with Commissioner Nissen to try and go to other areas. But also we're signing MOUs with another organizations to work around, the issue of, we call it the concept of community human rights defenders, to actually champion in communities people who can work with us in order to advance human rights. But also in terms of visibility, Chair, we also had meetings this year with NSFAS around the whole issue of access to funding at further education. And we've met with them twice. Now they're asking us to assist them, in dealing with their complaints, handling mechanisms. We also have a think tank on child rights, which includes many other organizations, UNICEF, Social Development, Center for Child Rights Institute in Cape Town, Child Law Center, a whole lot of NGOs working around child rights issues. And of course, also our moot court, which applies in all schools in the public schools in this country, also shows you the kind of the footprint we are able to have. But of course, we always have to, keep on improving on this. And I think maybe we need to, when we submit our report, our annual report, we should actually show in greater depth as to what we have done as far as, increasing our footprint and making sure we also reach out to rural areas. But certainly we use a lot of radio as well. Our provincial managers and our provincial staff members go out. As I was saying, we'll be having this hearing in Limpopo in that school. Again, that's another example of us reaching out to rural and marginalized areas. But I think we'll have to maybe, as I was saying, structure how our coverage goes about, so that at least honorable members can also see that, it's not just media on the national news, but also our work with community radio stations, Lesedi, Motsweding, you name all those issues. They've got a very high penetration. And maybe we should actually show, for example, the number of interviews we have with Lesedi or Motsweding or other radio stations to actually show that, we are reaching out to a lot of people. But the challenge still stands there that we could do a lot more, Chair. Then on the issue of the NPM, I'm trying to find my notes here. The NPM budget we have now currently, it's about 2.6 million, which we have got as a ring-fenced budget. But as I was saying, Chair, this is the last of the 3 years. So we'll be engaging with Treasury as well as government to see exactly how do we then fund the work of the NPM going forward. But we are working with other bodies like JICS, IPID, Military Ombudsman, and which other one again? To try and see how we can structure the NPM, because as you recall, Chair, the Commission has a monitoring role as well as a coordinating role. And when we submit our NPM second report very soon, again, members of the committee will see the kind of work which has been done by the Commission around the work of the NPM, which, as far as we are concerned, is definitely quite a successful work. I know we'll be having a conference in June this year, according to Commissioner Nissen, in Cape Town on the work of the NPM. And then, Chair, I also want to say that, on the concerns which have been raised around monitoring, we are developing a monitoring system very soon. We are also have a budget to employ monitors in all the provinces who will help us to monitor issues of human rights. And we've prioritized 3 main issues, but the 2 ones are actually issues of education, working together with Commissioner Gam, that we want to monitor what's happening around schools, especially under basic education. And that 2 main areas which we are looking at, maybe 3, it's sanitation, water and sanitation infrastructure, as well as the issue of violence and bullying in schools right across. We have had meetings with the South African Council of Educators to see how we can address this, because we are quite concerned about what is happening in that. So the plan should roll out very soon, and we should be able to report to the portfolio committee as to what we've been doing. And of course, the issue of health, again, we also want to focus on how the vaccination rollout will happen, to make sure that, also the concerns which have been raised about, how do we reach out to rural areas as far as vaccinations are concerned, but also how then do we, improve our health infrastructure to make sure that, we're able to survive the impact of COVID-19, because we are quite aware that COVID-19 is not only undermining our economy, it's also undermining human rights. At the same time, it's also highlighting the fault lines in our community, in our societies about, inequalities in our countries, the divides between the rich and poor, but also the challenges around government in terms of providing services to our people, in terms of facilities and roads and stuff like that. So COVID-19, while it is a threat to everything else, but also creates an opportunity for all of us to really look at ourselves to say, as a country, as a government, what have we been doing around that? So our monitoring plan will basically help to look into these issues. And of course, the work around the NPM also, we want to strengthen this so that we can also, monitor as many police stations as possible, but also work with other bodies. So, for example, we've been asked to assist the Military Ombudsman in some of their complaints. We also work, Chair, with other chapter institutions. As I was saying, for us, the conference in March was quite a fascinating one, because I think for the first time, we basically invited all chapter institutions. The AG came and gave a talk on corruption and human rights, the Public Service Commission, Public Protector, and IPID, and everybody was, including the Minister of Justice, just to look into the issues of corruption. And again, those are issues which still have to be continued. And therefore, as I was saying then, our work around our desire to protect whistleblowers will also require us to engage with many other people who are working on these issues of whistleblower protection in order to increase the work we're doing as well as our visibility. Chair, if I've left anything else, I'll ask my colleagues here to fill up the gaps in case I've missed anything. Sorry, my papers flew all over the table. So thank you, Chair.
Well, thank you very much. Thank you for the responses. I think we have run out of time, but I think we've taken note of the responses you have given us. But indeed, on behalf of the committee, we must take this opportunity to congratulate you for the steps you have taken to cut, in fact, to come up with innovative ways to try and cut that to the extent it is possible. These are very difficult times. The national fiscus is struggling, the economy is struggling. So we are called upon as managers, as leaders, as public servants, as public office bearers to assist the country by trying to ensure that we try and work with what we have, and we come up with all the innovative ways to try and find resources to continue to implement the programs that we have presented to Parliament that will be in a position to implement. So we are really encouraged that you have been able even to forsake some of your comfort to ensure that you unlock resources so that programs can be funded that are meant to serve our people better. We hope that when you come back, you would have, as the chairperson has agreed that he will do, you would have dealt with the issue of the SMART principles in terms of your plans, so that we're in a position to monitor you better. And the implementation of the SMART principle also is one of the ways of ensuring that we have resources that meet the targets that we have set, and it also assists in ensuring that we deal with wasteful expenditure. So it's important that we must stick to it, and we must try and ensure that we work according to it. So thank you very much, Chair, and to your team of commissioners and senior leadership, senior managers of the South African Human Rights Commission. And we just an update. We have concluded interviews of the two commissioners. We are hoping that by the time the House rises, which is going to be on the 4th of June, we should be in a position to have recommended to the House and to the President as to who becomes the Deputy Chair and the other full-time commissioner. That who is under control will be able to, I think we're working very hard to ensure that this term we finalize that particular process, so that we can also, that will help the Commission to be able to meet its targets and to lessen the workload on some of the commissioners and to the management of the committee, of the Human Rights Commission. Thank you very much, Chair, for your attendance, and to the commissioners for keeping the fort during these difficult times. But we're doing whatever we can to ensure that you get your commissioners that can assist you very soon.
Thank you, Chairperson. Thanks for your leadership and guidance. We appreciate it. We appreciate the support once more of the Portfolio Committee and all its honorable members. Thank you.
Thank you very much. Members, let's have 3 minutes break, and then we will invite the Deputy Minister, if he has joined, to lead us on the, we'll be dealing with the traditional courts. Thank you very much. Let's come back at 13 minutes past 11.
Thank you, Chair and Commissioners.
Thank you.
Everyone.
Good morning again, members, and to everybody in the virtual platform. The last time we discussed this matter of the traditional courts, we were failed by the information technology, so we could not hear. I think it was Ms. Mkize who was presenting on that day. So we decided to defer the discussion to a later date, which is today, so that we can continue with the presentation. I think she was responding to questions from Honorable Breitenbach on that day when I think when things fell apart and we could not really hear one ear and could not hear her on her side. So we thought that we should proceed from there. Ms. Mkize, are you on the virtual platform?
Greetings, Chairperson. It is Ms. Ngema, indeed.
Ms. Ngema, my apologies, Ms. Ngema. Sorry, Ms. Ngema. I also understand that the Deputy Minister is also part of the meeting. Welcome, Deputy Minister.
Thanks very much, Chairperson. And good morning to all the honourable members.
Thank you very much. Can I hand over to Ms. Ngema to proceed? I think we can see her clearly today. I don't think that there will be that sabotage again, so that we can be able to take this process forward.
Thank you so much, Chairperson. I'm trying to put up the presentation. Chairperson, the presentation is appearing on my side. I trust that it is also appearing on the side of the members. Basically, when we had connectivity problems, there were 3 questions that were posed, which I was ready to respond to. And the first question was, why has your opinion changed from what you last said on the constitutionality of the Traditional Courts Bill? The second question was, what is the meaning of opt-out principle? And the last question was, what happens if mediation process fails? So these are the 3 guiding questions that the presentation the members are seeing will be speaking to, Chairperson. I will first address the question about what changed. Chairperson, I think before we venture into the changes, if there were any in respect of the opinions, we need to appreciate that the opinion of 2018 that Legal Services presented, it was speaking to the bill that was introduced by the Minister before Parliament. And that bill was very clear, expressing that for the litigants, the one that decides to put a dispute before the traditional court and the one that must come to respond, they both must make a consent or they both must be voluntarily willing to participate in the traditional court. And hence our opinion was asked based on that bill by the chairperson and the portfolio committee at the time to say, what would be the position constitutionally if such expressions were removed in the bill? And that is where our first opinion was, and it was basically speaking, it concluded that removing the opt-out clause, as the bill was already constitutionally certified by the state law advisors as well as certified in Parliament, as was introduced, and the tagging confirming that it is constitutionally in order. That was the position we indicated, that what is being said by the bill as it stands is constitutional. And then the 2021 opinion, Chairperson, asked a question in light of the D version. And the D version was the bill that incorporated the changes by the portfolio committee and the changes by the select committee. So having looked in total of what the current bill that is before the committee today is stating, it was then the question of constitutional scrutiny on whether, with or without the provisions that express whether the parties can opt in or opt out, will that still stand constitutional muster? And that is what our opinion was addressing, in fact, in both instances. So the only thing that changed was the content and the bill that we were speaking to when we speak about constitutional scrutiny. The B version was clearly expressive, the D version was not expressive. And we concluded in both opinions, especially the 2020, that with or without explicit opt-out, the bill will still pass constitutional muster. And why we have argued that position, it's because, Chairperson, if we look at the issues the bill addressed, there were 3 rights that were at interplay, and that is Section 34, which provides a right for a litigant to take any dispute to a court of choice or a tribunal or a forum. The second right is the right in Section 30, read with Section 31, which provides a choice to be involved and participate and enjoy any cultural life that you choose. So the question that we were addressing, and we have looked at the bills as they stand, is the question, what is the presumption and the intention of the legislature that it wanted to address? The first question was, the Traditional Courts Bill, once it becomes enacted into law, it will be law of general application. That means it must apply to anybody without being specific that certain individuals it will apply to and other individuals it won't apply to. The second principle that the bill was considered under, did it consider the limits of the conflicting rights in light of Section 36? So what we did, we contrasted Section 36 as well as Section 34 and Section 30 and Section 31 to see if the bill as it stands, did the legislature consider what those provisions of the Constitution are indicating? And in light of having to look at that balancing effect, we have verified, and we are of the view that the limitation of rights and the balancing of the rights that are conflicting, as I have indicated, and is accordingly and appropriately done in line with Section 36 of the Constitution. And because those rights are conflicting, the policy that came from the executive indicated a position which was accommodative of both the litigants. Whereas the position that came after the Assembly approved the B version, it only gave accordance to the right of the litigant that wants their dispute taken in the traditional court. So the one that must respond once the dispute is litigated must follow suit and the jurisdiction that is chosen by the one litigating as the first applicant. Secondly, Chairperson, when we looked at how these rights were conflicting and in terms of what the bill in the D version currently points out, we have identified that Section 36 was applied by both the Houses of Parliament through the Portfolio Committee and through the Select Committee, enabling them to conduct an exercise that deal with conflicting rights and ensuring that none of those rights then, using the balancing exercise, do not unreasonably and unjustifiably impair on the other. Therefore, Chairperson, what we found on the bills, as our opinion pointed out through the 2018 opinion, as well as the 2021 opinion, was the fact that the balancing exercise conducted by both legislatures is very clear and is very lawful in the sense that the legal certainty that is required is coming out of the current provisions of the D version. It is clear that the one that applies Section 34 will be able to follow in light of Section 30, the cultural life that they have chosen, if they are living a life that must be regulated following the traditional courts should a dispute arise. Secondly, Chairperson, the proportionality test was conducted, if we look at the provisions of the bill, to show that the rights that must be limited on the other party is justifiably limited. And it is clear how it was done. Therefore, Chairperson, the question on what then changed in our opinion, we've answered it by saying that through the application of the limitation test or the limitation of rights provision in terms of Section 36 and the proportionality test with the rationality that explains why such legislation must be enacted, that has been done through the bill. Secondly, Chairperson, we've also, from the question asked as to then what is meant by opt-in and opt-out, we pointed out that in our opinion, it was clear that we were saying both litigants were able to exercise the opt-in or opt-out. But what this current bill, the D version, does is to give only the principle of opt-in. And therefore, Chairperson, we are still of the view that the B version, as it was amended, which at the time we gave our first opinion, there was no option. There was no draft version to say, this is what you are weighing. You are balancing and looking at the introduced version by the minister, or you are balancing the version that is now changed by the portfolio committee. We are then now saying today, and when we made the opinion in March, that was presented before the committee, the D version as it stands, and the B version that was then amended by the portfolio committee, all these three bills, in light of the principles that I've explained, that the law, once enacted, will be very clear. There shall be legal certainty, and it shall be law of general application. And lastly, if there is a limitation of rights, is such limitation justified? We are saying the current D version as it is, considering all those principles and seeing that the legislatures did take those principles into consideration, the D version will definitely pass constitutional muster if it's taken to court to assess the scrutiny of its constitutionality. Then, Chairperson, the second question that we had to address was to explain what is meant by the opt-in and where it derives from. We did indicate in our initial opinion, Chairperson, that the opt-in principle was sort of introduced into our law through the class actions that came in when we had the Bill of Rights entrenched in the Constitution, because there's still the autonomy of people to be individuals when they are collective action. That basically, that principle was indicating that if people still want to maintain their individual autonomy when there is collective action, you can make a choice whether you want to be part of the collective decision or you want to act on your own. Therefore, the principle of opting in if you want to be part of the collective, or opting out if you want to remain an individual and not be bound by the decisions or the impact out of the collective decision. But for purposes of the Traditional Courts Bill, the issue or the principle of opt-in arise from the dictate of Section 30 and Section 31. If we read those constitutional provisions, they are very clear that when a person engages in the cultural life, it is their choice. It is again the rights that are at interplay with what the Constitution stipulates in Section 235. People can enjoy and participate in the right of their choice. But now, what is being argued for purposes of the traditional courts is the issue when we are regulating the traditional courts. Should people then be forced to follow the traditional courts? And I think what was clear from our first opinion is the fact that what we are arguing is the recognition of customary law. That customary law has already been recognized and is in lawful existence in terms of Chapter 12 of the Constitution. So when a person has decided to undergo a justice system that goes through traditional courts, that is a person's right following a recognized source of law and a recognized way of living. Therefore, it cannot be said that if such a person makes such a choice and makes a choice on the jurisdiction where their dispute will be tried, the other person can take away that, because that again will be taking away the right in terms of Section 34. That is where then, Chairperson, the legal arguments for purposes of the traditional courts and the submissions that has been taken away were arising out of Section 30 and Section 31 of the Constitution. And then, Chairperson, again, in light of that, we are still of the view that what the bill as it currently stands as a D version, it can actually pass constitutional muster and did a proper interplay and proper looking at balancing those three rights as they were conflicting. The last question, Chairperson, was on the process of mediation and what happens if mediation fails. The process of mediation, Chairperson, comes out of the provisions of the Constitution in Section 76 as well as Section 78. The bill, the Traditional Courts Bill, was tagged as a Section 76 bill, and the minister introduced it before the National Assembly. Then that means it followed the provisions that are outlined in Section 76(1) of the Constitution. The mediation process is also dictated or provided for in terms of that section. It occurs when the bill has gone through its legislative process, but because of whatever changes that have come through, as the current Traditional Courts Bill now has a version that was passed by the National Assembly, which is a B version, and a version that was passed by the National Council of Provinces as a D version. The matter is now before the Portfolio Committee to look at the D version. Should the deliberations today on the D version not be supporting what the D version is providing, then that is where, if the matter goes to the Assembly with the report of the committee stating that we are either not supporting the changes from the NCOP or we are rejecting the D version, then the decision of the Assembly in terms of the rules of the National Assembly will then dictate whether the process needs to go to Section 78, which is the mediation process. And the mediation process, as outlined in Section 78, is a process which will involve both designated members. There will be 9 members from the Assembly, and there will be 9 members from the delegates of all the 9 provinces to sit as a mediation committee. The mediation committee will be provided with the bill as was introduced by the minister, which is called the Traditional Courts Bill 1, 2017, as well as the B version, which was changed by the Portfolio Committee, called the Traditional Courts Bill B1 of 2017, as well as this version, which is the D version, changed by the National Council of Provinces. Should the mediation committee not approve any of the 3 bills, because the joint rules, as I mentioned them, Chairperson, at joint rules number 185 to 189, they set out the process, what will happen. But should neither of all those bills be approved by the mediation committee, that is when mediation would have failed. And if it has failed, the joint rules are providing that the matter must then revert back to the House, and each House must deal with the matter in terms of their own rules. But specifically for the National Assembly, the relevant rules that will address this issue is National Assembly Rule 315, which also speaks to the 3 bills. And the Assembly will then have to make a decision and pass it with the vote as outlined in Section 50, I think it's Section 58 of the Constitution, to say, which bill must then pass now that we are having 3 bills, or there will be another 4th bill that will be provided by the mediation committee should it get to that. So there is no space. I think last time I indicated that the bill automatically lapses if the mediation fails. What must happen is that the matter must go back to each house and it must be deliberated and the decision voted on and then taken. But if that does not happen, for an example, if the mediation committee does not meet within the 30 days, the minister who is said to be the one in charge of the bill when it was introduced may again, in terms of National Assembly Rule 315, make a request to the speaker to indicate whether it is the Assembly bill that must be passed or what must be the position. So 2 instances may happen. The houses will decide, and if they meet each other, that bill which they agree on will pass and will go to the president. But if out of all the 4 bills, none of the 2 houses are meeting at ad idem, then the minister may make a request which of the bills must be voted on, and then it will be put on the order paper. And if the National Assembly passes that bill, then that will be the position the Traditional Courts Bill takes. But for now, it will all depend on what is the decision of the committee today. Does it pass the amendments of the National Council of Provinces through the D version, or does it reject the bill? Because I think one last thing I must add as I wind up, Chairperson, is that in terms of the rules of the Assembly, there are no amendments that can be proposed to the D version. And that is why we then have to follow through the process of mediation if there is no agreement on the D version. Thank you, Chair.
Thank you very much, Ms. Ngema. Can we remove the slide so that I can be able to see members? I have Honorable Verma, followed by Honorable Ngola. Honorable Breitenbach, Honorable Vela, Honorable Nivot Trochen.
Thank you, Chair. Thanks. I'm still trying to read through the mediation process, but I'm not going to ask that question yet. I wanted to ask Ms. Phumelele, if one person wants their case heard in the traditional court, but the opposing person, who's the respondent, doesn't want it in the traditional court, they want it in a normal court, what happens if the 2 of them oppose each other?
Thank you very much. Honorable Ngola.
Thank you very much, Chair. As our tradition, I welcome the presentation of the Traditional Courts Bill. Chair, I have a comment and a proposal to the committee. I've got the presentation in detail, and Ms. Ngema has done justice in terms of outlining what were the issues, how did they go about in trying to ratify some defects and all that and all. Chair, the institution of traditional leadership is too complex. Is too complex, Chair, on the basis that at some point it differs from one tribe to the other, it differs from one community to the other, it differs from one village to the other or one place to the other. I want us, Chair, to be meticulous when we're dealing with this particular bill, so that we curb the risks that it carries. As the explanation goes on, you listen, there are some risks here and there and here and there. We know, Chair, with the history of statutes as Parliament that have been challenged to a number of courts. Some of them were declared null and void. So I want to plead with the committee, Chair, to be very meticulous when we are dealing with this matter. The first point I want to raise, I did not hear Ms. Ngema saying, in all these things of mediation, opt-out, opt-in, what was the view or the submission of the House of Traditional Leaders in the opt-in, opt-out mediation issues? The second chair would go to the committee, to yourself and the entire members of the committee, to propose that chair. Let us maybe for the last time take the bill as it is presented and solicit the services of a senior counsel in the legal unit of Parliament to take us through again with the legal risks, the strengths and the weaknesses of this bill. How do we go about making sure that we don't make legal defects in terms of going forward approving it? So I would like to make that proposal to the committee that we must solicit services of senior legal counsel in this matter for the last time maybe. I've heard that there was one in 2018, there was one in 2019. Can we have the last one so that one meticulous in dealing with this matter? Thank you very much.
Thank you very much, Honorable Mola. Honorable Glenis Breitenbach.
Thank you, Mr. Chair. Good morning to everybody, and thank you for the expanded input on the legal opinion. Ms. Ngema, I've listened very, very carefully to your additions and your explanation, and I say this with the greatest of professional respect to you. I fundamentally disagree with your departure point. I cannot reconcile myself to a bill that disallows vulnerable members of the population who are not lawyers, who do not have easy access to lawyers, who already struggle with access to justice in the mainstream courts, for want of a better expression, and not to denigrate traditional courts at all. I have the greatest, as a lawyer, the greatest respect for customary law and traditional courts. But people already struggle with access to justice. And this bill, with a stroke of a pen, is going to subject millions of people, but more particularly women, to a system that they do not want to be part of necessarily, that they do not necessarily view as fair, to a system that is, again, with the greatest of respect, deeply patriarchal. And I cannot reconcile myself to a bill that with a stroke of a pen subjects those members of the population to a system that they do not want to be part of, and they have no choice. The principal litigator wants to litigate in a traditional court, so be it. Then the second litigator, the person who's dragged along to court, has no choices. They have to go through the entire process, and I went through this the last time, you haven't answered it. They have to go through the entire process. Then when that's over, they have to approach a court, an ordinary court, to have it set aside. How will they get there? Who will advise them? Who will pay for it? It's going to create such an untold mess. And I say that again with the greatest of respect. I see nothing but trouble. I see nothing but unfairness and trouble. And I cannot reconcile myself to it. So without an explicit, and it doesn't matter how many times the Honourable Deputy Minister says that it's implicit, without an explicit opt-out clause, I believe this bill is unconstitutional. I believe it entrenches inequality, and I cannot support it. I must align myself with the suggestion of the Honourable Ngola, and this is again no disrespect to yourself, that perhaps we should seek a second opinion from an outside third party SAHRC who is not at all invested or involved in this matter, who can bring us an objective view. But as the bill stands, I cannot support it, and I cannot advise my party to support it. Thank you, Mr. Chair.
Thank you very much, Honorable Chela. Maseko Chela.
Thank you, Chair. And thank you also to the presenter. Good morning, members. Chairperson, I only have one question to Ms. Ngema. The manner in which, because this bill, in honesty, most of the people that are going to benefit from are our people from the rural areas. Even if, yes, we do benefit from the urban areas, but most of the people who really would appreciate to have such a bill are the people, like I said already. So I just want to find out from Ms. Ngema, the manner in which it is been presented with all those opt-out and opt-in, was it presented to the traditional leaders? And I'm not sure, because remember, some of us we are just joining the committee, and we hear that they will have been the first virgin, second virgin, and this one too. So I just want to find out the views, if ever there were views in line with what now it is really holding us. What was their views, Chair? Only that one. Thank you, Chair.
Thank you very much, Honorable Deputy Minister.
Thanks very much, Chair. Look, I just wanted to make a few comments. And let me just start with what Honourable Breitenbach said. This bill is going to subject millions of people to an unjust system or whatever. I can't remember the exact wording, sorry. This bill is not creating traditional courts. Those traditional courts are already there. This bill is trying to regulate those courts to make them consistent with the Constitution. Yes, the bill that was introduced had an opt-out clause. It came from a reference group of traditional leaders and civil society people. As I've said before, the idea was the aim was a bill that people could live with, not one that everybody supported. And we got that, a bill that people could live with, but probably nobody was particularly keen on it. But the problem largely is that we have a dual system in our country. Because of our history, traditional, the colonialists, the Boers didn't take all the land. Some land was left, which remained in what were called reserves, which were under traditional leaders and customary law. And those areas were then put into the homelands, into the Bantustans. But this dual system is recognized in the Constitution, and I think it's chapter 10. And that's the reality. It's there. And there are traditional courts that are there. Sorry, not chapter 10. I think it's chapter 12. Yeah, chapter 12. Those courts are there. They're functioning. So I know from many of the people, particularly from civil society, I think there was a article somebody sent me sort of in memory of the late Miss Sizane Ngubane, which I thought summed it up, and she actually had attended some of the meetings of the reference group. But the article, it's by somebody called Richard Baber, spoke about the fact that she had campaigned with her rural women's movement, mobilizing rural women against these harmful pieces of legislation. They organized marches and sent people to parliament. While the traditional Khoisan Leadership Act was passed, the traditional courts bill was previously defeated, although devastatingly, it has been revived. And I think that for me sums up the issue. You know, some people see it as devastating that we have a bill on traditional courts. But, you know, our options are either we've got to change the constitution, abolish traditional leadership, outlaw traditional courts, or we've got to regulate them. And I think they do provide mechanisms for people to get disputes resolved. I think on the issue of whether it's constitutional or not, and with due respect to Honourable Nola, that will be for the Constitutional Court to decide. Ms. Ngema is quite adamant it is constitutional. I would have had a more conservative approach, would be that it may be, it may not be. We hope it's constitutional, but ultimately the Constitutional Court will decide. And we've seen even, you know, the Supreme Court of Appeal being overruled by the Constitutional Court on particular issues. The issue also anyway of constitutionality, I mean, Parliament has twice said this bill is constitutional when it was passed in the last term by the previous National Assembly, and then this term by the National Council of Provinces. So the issue basically is, okay, even if it isn't constitutional, can the NA at this stage do anything about it? Because it's been said that it's the limitation for the National Assembly is to look at the NCOP amendments, which, you know, quite frankly, are pretty basic standard. There's nothing particularly substantial in them. Changing reference to the Traditional Leadership and Governance Framework Act to applicable legislation, some typos, those kinds of things, changing the name of the bill from 2019 to 2020. Well, we're now on 2021. And by the way, again, some of the civil society, well, it's one particular organization that if you look at all the media reports or media articles written, that is spearheading its opposition to the bill. And I think they should actually come out and say, do you support traditional leadership or not? But anyway, they had the cheek, I think, to say that this bill was being rushed. It's not being rushed. But anyway, the point I'm making, Chair, is that even if it is constitutional, can the National Assembly consider any further amendments? The President, has it not shifted to the President, who has the power to refer a bill back to Parliament if he believes it may not be constitutional? Because my concern about further opinions is you may get some that say yes, you may get some that say no. Ultimately, it's the Constitutional Court that will decide. So I just sort of want to raise that as a concern. I noticed that Honourable Breitenbach in the previous meeting had raised concerns over the issues of gender. Just to say, in the reference group with some pretty prominent feminists, there was no disagreement on the clauses relating to the participation of women. But I think my key concern is that in the first meeting that the previous minister and I had with both civil society and traditional leaders, civil society, including I remember Ms. Aninka Klaassen from LARC, who are very active on this matter, had said that the bill was urgently needed. And unfortunately, we discovered later that although one thing was being said, there were other attempts to undermine the process to try and come up with a bill. But the concern is if it's not finalized, those courts continue unregulated. So, Chair, I just wanted to raise those points. And then maybe the other issue is that when the first version, I think that's the B version, was passed in the National Assembly, The then Minister of Cooperative Governance, who was Dr. Zweli Mkhize, it was the last administration, did have consultations with with traditional leaders, I think the National House, and they accepted the bill. So it then obviously had to go to when introduced. Well, that was the B version, which is substantially what you have now, just with the NCOP amendments. I'm not sure if Ms. Ngema was aware of that, but from the executive side, I'm aware of that. But anyway, so the point I'm making basically is concern that this bill has been around for a long time. It's been debated. Yes, even members of, and again, to correct something, I saw that somebody from LAHRC had claimed I'd said, the reference group, not all the reference group members are happy with this version of the bill. They wanted the opt-out clause in, and that was in the bill that was introduced. Parliament made not just, or the Portfolio Committee didn't just take it out, it also, though, changed things to allow for appeals to the Magistrates' Court. So it wasn't a question of just taking that out and putting it back in. But anyway, so yes, it's controversial, but we can debate for another, we've been debating this bill for 20 years, I think. We can debate it for another 20 years, and all the while the courts continue when I think it's better if they were regulated. And on the constitutionality issue, I would say, can the National Assembly make amendments if they have concerns over the constitutionality, or is that issue now with the President if the bill is passed, who can just refer it back if it is deemed to be, or if it's concerned that it might be unconstitutional? Thanks, Chair.
Thank you very much. Over to you, Ms. Ngema, to answer the questions that were asked to you.
Thank you so much, Chairperson, and thank you to the Deputy Minister and to the questions that have been posed. Chairperson, I think on my side, it's mostly two questions that I need to tackle. Firstly, I think it will be the last one that asks whether the National House of Traditional Leaders did make an input in terms of the tagging processes and the public hearings and what took place when the bill was before the National Assembly. The referral in terms of Section 18 of the Traditional Leadership Framework Act was done because this is a Section 76 bill, and it also relates to issues of customary law and customs. Therefore, Chairperson, the National House of Traditional Leaders' inputs was sourced officially, and it was part of the presentations as well when it took place earlier on. In terms of the other question, which was first as to what happens where the opposing litigants do not find one another in terms of confirming the jurisdiction, the Deputy Minister did touch on that. The process as it appears on the bill, Chairperson, it allows that the process must go through right to the end with the party that is not keen to be going through the process, but then there's been an added provision that takes the case to review where the party was not happy in the processes. As I said, Chairperson, those are the two questions. In terms of the input, the Secretariat Office can present the written submission that was sourced from the National House of Traditional Leaders. Chairperson, thank you.
No, thank you very much. Let me start by saying, Ms. Ngema, I think you have...
I'm sorry, Chair. I'm sorry, Chair. Chair, I'm sorry, my computer does not have a hand raise facility. My name is Teresa Ross from the Department of Justice. On the question that was raised by Honorable Velma, that Ms. Ngema has just spoken to add to that, if a party, in terms of the bill, if a party does not, like she says, they don't find themselves in terms of appearing before a traditional court, then a clerk of the traditional court will then make a determination to that effect, to the effect that the other party is not willing to appear before the court. And then thereafter, the matter, the clerk of the court will then, that is in terms of the bill, will then refer the matter to the justice of the peace, who will then negotiate or mediate with the party who is not willing to participate in the process. But that is just as far as it takes the matter, because then the justice of the peace will then perform his or her functions in terms of in line with the Justice of the Peace and Commissioners of Oaths Act. Thank you, Chair.
Chair, can I just add on that?
Proceed, Chair.
As I mean, following on, just Ms. Ross should have gone a bit further. You know, as she said, it's up to if the person doesn't appear, then it goes to the Justice of the Peace, who must go and try and speak to the party who doesn't want to appear, and it's clause 44B(2). Then effectively, if the party against whom the summons was issued is the person who didn't comply, then the Justice of the Peace can request the traditional court to have the matter transferred to the Magistrates Court having jurisdiction. But to Honourable Breitenbach, you know, I think currently, I mean, things differ from court to court, but I think currently, in many places, people are forced to participate. This, as far as I would see it, is that that there isn't forcing. And then otherwise, remember that the bill does have the broad principles of what is it? You know, the voluntary nature of customary law. So there are those principles throughout the bill as well. But I just sort of wanted to raise that. So there isn't actually a provision, there's no provision in the bill that you have to attend and that there's any penalties if you don't. What's in the bill is provisions that if you don't, it can be referred to the Magistrates Court. Thanks, Jay.
Thank you very much, TM, and to Ms. Ross. Let me take this opportunity to thank Ms. Ngema for diligently applying herself to the task that was given to her. I think it's important that as the House, whether ultimately we can be found to have the bill might be found to be constitutional or unconstitutional, but what is important for us as Parliament or as the National Assembly is that at the time the bill is passed by us, we must be convinced ourselves beyond doubt that the bill is constitutional. And we should take every step to ensure that we are convinced as the relevant House that the bill that we pass is constitutional. The President is not the member of the House. If the bill reaches the desk of the President for assent and the President refers the bill back, it's part of the constitutional dispensation that allows for that. But it would be bad if we transmit the bill as Parliament to the President when ourselves we are not really sure. It's important that we must have satisfied ourselves that at the time the bill is transmitted to the President for assent, we have done our work diligently, and we believe in the product that you are sending to the President. So I think there is a proposal that is before us that was seconded by members of the committee, that notwithstanding the fact that Ms. Ngema has diligently applied herself, the problem is not with her product. The problem is that there's still uncertainty amongst us as to whether the bill is constitutional. We are of the view that in the meantime, let's get an outside senior counsel to take the doubt in our mind as to the constitutionality of the bill. It's not a matter of being right or wrong. As the Deputy Minister has already indicated, that even amongst the courts, it will be taken to the High Court, to the Supreme Court of Appeal, then to the Constitutional Court. But what is important is that at the time we conclude the bill, we must be convinced that we have done everything possible to ensure that we pass something we believe in, and we believe in its constitutionality. Therefore, there is no objection from the members of the Portfolio Committee that the bill be sent for an outside senior counsel, either to corroborate what Ms. Ngema has said, or to point us so that we can be able to consider everything else that might come, so that we would be convinced that the bill that we would have passed is indeed constitutional. Is that in order, members?
It is, Mr. Chair. May I say something?
Honorable Breitenbach.
Thank you, Mr. Chair. I just want to correct something the Deputy Minister said, and I'm sure he didn't mean it that way, but he said, I said the traditional court system is unjust. I never said so. I don't for one moment suggest that it's an unjust system. I never did. I just want that to be quite clear. Thank you.
Thank you very much.
Can I just come back? I didn't intend, let me just say, I didn't intend to say that. I think that so I accept that Honourable Breitenbach had raised concerns around possible injustices, and that was the issue I was addressing. So no dispute, I hope, with her.
Okay. Well, thank you very much, Deputy Minister. Thank you for clarifying that. Thank you very much. Thank you very much, Ms. Ngema, for the hard work and for you applying yourself thoroughly into what we have asked you to do. Thank you very much.
Thank you so much, Chairperson and the members. Thank you.
Thank you very much. Members, we have a bit of a challenge. We still we need to deal with the report of correctional services and the report of the salaries for both magistrate judges and Chapter 9 institutions, the adoption of the minutes. Those are issues that are still outstanding. I propose the following, that we deal with the substance of the program, in fact, of the agenda. And then when it comes to voting, I will appeal to all parties to ensure that their members are present or their alternate members are present in case their main members are not present, so that we have the required quorum to vote, to approve the budgets. We will deal with the budget for correctional services, the Office of the Chief Justice, and we will vote for the budget of Justice, Department of Justice next week, because we have just received a briefing on South African Human Rights Commission, so they would need to also include that So by next week, we will be ready to vote on the budget on the Department of Justice. So today it will be Office of the Chief Justice and the Department of Correctional Services that will be voting on. So can we start generally dealing with the content, and then when it comes to voting during that process, can the leaders of parties that are present ensure that their members are present too, so that we do have the quorum to pass all the issues that we need to vote on, including the salaries. Is that acceptable, members?
Yes, Chair.
I'm sorry, Mr. Chair, can I just ask you to confirm we want to deal with those today?
Yes.
Oh, all right, I'll try. Thank you.
Yes, because for instance, in terms of the parliamentary program, we need to vote on Tuesday, to debate on Tuesday the office of the Chief Justice, and which means by today we should have voted on that budget vote, whether it is approved so that it can go to the House or not.
Chair, can I be excused?
Okay. I was under the impression that you would want to lead the discussion for the salaries. Oh, no, you did that. Sorry, Tim. Sorry, my apologies. I know that you will. I will pay for it for the next 6 years. My apologies. My apologies.
Okay, thanks, Chair. I can stay if there's any further questions. If you're willing to if it's possible to do the salaries first, but just for it's obviously not appropriate for me to be making inputs into the committee reports.
Yes. No, thank you very much. No, you are excused, Deputy Minister.
Thanks, Chair. Thanks, everybody.
Thank you very much. Can we start with dealing generally with the content? And before we go to voting, I see the hands. Honorable Breitenbach and Honorable Niveau Drachen.
Sorry, it's an old hand.
Okay, thank you very much. Honorable Niveau Drachens.
Thank you, Chair. I just wanted to ask, do we have enough quorum to vote now?
I have just addressed that issue, Honorable Niveau, that we are going to deal with the content for now, and I've asked party leaders in the committee to ensure that their members are present, so they can start calling their members, so that by the time we come to the voting, we should have the quorum. Is that in order, Honorable Nebo Drachen? You are muted.
Thank you.
Okay. Thank you very much. Can we start with correctional services? Members, can we have a 5 minutes break so that we can respond to nature, and then we'll start with correctional services.
Thank you, Chair. Thank you for that.
Thank you. Thank you. Thank you very much, members. Are we all back?
Yes, Chair and the Honourable Horn has joined us.
Oh, thank you very much. Now we do correct now. Thank you very much, Honourable Breitenbach, for your help. Thank you very much. And to Honourable Horn, thank you very much. We will start with the report of the Portfolio Committee on Justice and Correctional Services on Budget 22, Correctional Services, dated 14 May 2021. We will start with the correction members before we move for the vote. Page 1, do we have any corrections that we want to make on page 1? Let me just, I think members just indicate, because I won't be able to see you. If I press participants, then I won't be able to see what is written. So just indicate, just raise your voice, then I'll be able to note you. On page 2, on page 3, on page 4, on page 5, on page 6, on page 7, on page 8, on page 9, on page 10, on page 11, on page 12, on page 13, I think there is Honorable Taylor.
Let's go up. It's like there's a word that is combined there. Let's check. On top, yeah. Let's go on 12. Yeah, this one. Is it okay? Hang on. 8.1.1. Is it one word? This one, inkosi or inkosi? Okay. No. I see now. Okay. Thank you, Chair. I'm fine. I thought that is something else. Okay.
Okay. Let's go up. Sorry, I think let's look at the committee recommendations. I don't see it now, but there is a sentence that has bad queries. I don't see, where is it now? I saw it last night. What I can say, just look at the grammar much more closely. Just look at the grammar more closely. I saw two issues yesterday night. Just not to hold the meeting at ransom. Just look at the grammar again much more closely.
We'll do that, Chairperson.
Sure, thank you very much. Can I put the report as a whole before the committee? Is there any mover? Honorable Nivolt.
I move.
Honorable Nivolt moves. Is there any seconder?
I second, Chair.
Honorable Ngola seconds. Anyone objecting?
I reserve the position of the DA, Honorable Chair.
The DA reserves its position.
As usual.
Thank you very much. The report is adopted.
Now your tree works.
Yeah, good cool, comrade Nola.
Let's move for the next item. Committee Secretary, let's move to the next item. Welcome, Honorable Horn. Mr. Mtonjeni. Members, there is a network problem. Sia is attending to it.
Chris, can you stop sharing? Maybe I can try. Chris, can you meet?
Sorry, I can't. I'm trying to stop share call.
Okay, and let me try and share quickly. Thanks. Is it fine?
Yes. Thank you very much. A report of the Portfolio Committee on Justice and Correctional Services on the annual performance plan for 2021-2022 of the Office of the Chief Justice and Vote 27, Office of the Chief Justice, dated 14 May 2021. Are there any changes or corrections that members proposed in page 1? Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Honorable Nivo Trahan.
Yes, sorry, Chair. My iPad doesn't show the page numbers, so I'll go to the point. 3.4, that one. In the table, go up. 3.8, sorry. Oh, 3.4, that one. That table, MTSF, the MTSF table, priority 1 says, in the middle column, it says, it says percentage if, it should be percentage of. So percentage of. Percentage of staff. In the middle column, priority 1. Okay.
Thank you very much.
Okay, I see there's of there, yeah. So
Page 9. Page 10.
Chair Wilma, page 10.
Okay. Honorable Nivo Trahan.
3.8.2.
Go down.
No, wait. Sorry. Sorry, Chair. It's 3.8.1. 3.8.1, the second bullet. You see, it says 2021 and in 2023/2. What does that mean? It's supposed to be 24. Is the dates correct there? 2023/2. It's supposed to be 2023/4.
Sorry, can I interrupt? I think it's 21, 22, and 22, 23.
Yes. 22. Can you
Yes.
correct that, Christine?
I will, yes.
That is noted. Let's go down. Page 11. Page 12. Page 13. Page 14. Page 15. Page 16. Page 17. Page 18. Sorry, let's go up. Yes, 5.1. The committee understands the need for the budget cuts, but queries. Can't we have a different word for but queries?
Could we say does not support?
Or is concerned?
Okay.
But the one size fits all approach. Honorable David Rahans, you raised your hand.
Yes, Chair. 5.2. The last sentence says, additional, comma, after the additional. Okay, sorry, it's 5.2. Sorry, the 9th line, interpreter's mistake, 9th line, says has even additional, comma, that comma needs to be removed. Even additional capacity. There in front of capacity, there's a comma. Okay.
Thank you very much, Honorable David Rahans. 19.
Chair, me again.
Honorable David Rahans.
Thank you. 5.3. Somewhere there's a sorry, just clarifying. There's a word that is made into one that it's supposed to split.
Can we say, Honorable Drachen, that
Inefficiency.
Okay.
I saw it somewhere.
They will look at that. 5.3. Look at the word inefficiency. Can we move?
Mm.
$20. Into one. Can we move up? There is where you said at this promise. maybe what we need to do, just look at the whole documents for grammar. Because I think I was looking at the document very late yesterday. And then there were also areas that were raised by Honorable Neville Dragons.
Chair, can I just respond to say that I found the inefficiencies and have already changed it.
Okay.
Corrected it.
Okay. Honorable Neville Dragons.
No, Chair, just I typed in the chat 5.5 also to fix that.
Women on training to women in training 5.1. Also in 5.5, in the fifth line from the bottom. What does it say, Honorable Dragons? What do you want to change there?
No, Chair, it also says women on training.
Okay.
It should be women in training.
Thank you very much. Can I put the report now to the committee? The report as a whole. Is there anyone who wants to move for the adoption of the report with the correction made?
I move, Chair, for the adoption of the report.
Honorable Jelle moves. Is there any seconder?
I second, Chair.
Honorable Ngola seconds. Is there anyone who objects?
I reserve the position of the DA, Honourable Chair.
The DA reserves its position. Thank you very much. Let's go to the next item on the agenda. Thank you very much, Mr. Mtonjeni. The report of the Portfolio Committee on Justice and Correctional Services on the draft notice determining the rate with effect from 1st April 2020, at which the remuneration of Constitutional Court judges and judges dated 14 May 2021. The report was circulated to all members. It will be taken as read. Firstly, let's look at the corrections. Is there any member who wants to make corrections on the report? There's only one page. No one. Can I have a mover for the adoption of the report? Anyone who wants to move for the adoption of the report?
I move, Chair, for the adoption of the report.
Any seconder?
I second, Chair.
Honorable Nivo Drahan seconds. Honorable Nomathemba Jelle moves. Honorable Nomathemba Jelle Honorable Jelle moves, and then Honorable Nivo Drahan seconds. Anyone who's opposing?
Honourable Chair, we don't oppose, but I reserve my position. I must take it to the caucus, but we, in principle, are not opposed to the report.
The DA reserves its positions. Thank you very much. Thank you, members. Let's go to the next item. Thank you, Mr. Mtonjeni. The report of the Portfolio Committee on Justice and Correctional Services on the draft notice determining the rate with effect from 1st April 2020, at which salaries and allowances are payable to magistrates annually, dated 14 May 2021. The report was circulated to all members. The report is taken as read. Are there any corrections to the report? None. Is there any member who wants to move for the adoption of the report?
Let me move, Chair, the adoption again.
Thank you, Honorable Jelle. Maseko Jelle moves. Is there any seconder?
Honorable Neo Druchen seconds.
Honorable Vote Drachen seconds. Is there anyone objecting?
Yeah, reserves its position, Chair.
The DA reserves its position. Thank you very much. The report is adopted. Let's move to the next item. Thank you very much, Mr. Mtwanjeni. A report of the Portfolio Committee on Justice and Correctional Services on the notices determining the remuneration of the Public Protector, Deputy Public Protector and Commissioners of South African Human Rights Commission with effect from 1st April 2020, dated 14 May 2021. The report was circulated to all members. The report is taken as read. Are there any corrections to the report? Page 1. Page 2. Page 3. Page 4. None. Is there any member who wants to move for the adoption of the report?
Wilma Neo Druchen moves for adoption, Chair.
Honorable Nuvo Drachens moves. Is there any seconder?
And I second, Chair.
Honorable Jelle seconds. Is there anyone who opposes?
Yeah, reserves its position, Honorable Chair.
The DA reserves its position. The report is adopted. Thank you very much. Can we move to the next item? Oh, we are done with the reports, Mr. Mtwanjeni. Have we adopted all the reports?
Yes, Chair, we were done with the reports for with regards to the salaries, Chair. Those are the ones that are on there, Chair.
Before we come to the minutes, can we go to the regulations?
Nice singing voice.
Oh, sorry.
Yeah, no. The heart is happy.
Chris, can you share the regulation one?
I'll do my best. I don't seem to be very competent today with my screen.
You sing very well.
Okay.
I think I have the legal aid one. Just check for the payer one. I'll project the legal aid one.
Thanks, Sia.
Thank you very much, Mr. Mtwanjeni. Report of the Portfolio Committee on Justice and Correctional Services on draft regulations made in terms of Section 23, subsection 1 of the Legal Aid South Africa Act of 2014, Act number 39 of 2014, tabled in terms of section 23, subsection 2 of the Act, dated 14 May 2021. The report is taken as read. It was circulated. Are there any corrections on page 1? On page 2, none. Maybe if you can do your formatting, it will have only one page. Thank you very much. Is there any person who wants to move for the adoption of the regulations of the Legal Aid South Africa?
I move with that suggestion of taking, working on the format so that you can have one page.
Thank you very much, Honorable Maseko Chele. Is there any seconder? So no one wants to second this proposal?
Oh, I'll help you out. I'll second.
Thank you very much, Honorable Glenis Breitenbach. Is there anyone who objects? None. Is there any party that wants to reserve its position? None. The report is adopted. Can you move to the next item?
Chris?
Is it possible to start the minutes and then go to this one quickly, just because I have to just correct the heading here? See that something happened in translation.
Okay. Let's go to the minutes. Thank you very much, Mr. Mtonjeni. Draft minutes of the Portfolio Committee on Justice and Correctional Services, dated 5th May 2021. The minutes were circulated and are taken as read. Are there any corrections on page 1? Page 2. Page 3. Page 4. Thank you very much. Honorable Nuvot Trachans.
Sorry, Chair. Can we go down to up to point 2, please? There. At point 2, the second bullet, it says overview of plans of and allocation. So the grammar just needs to change there. Plans and allocation. So the word of needs to be removed. Needs to be removed. Great, thanks.
Thank you very much. Is there any mover for the adoption of the minutes as corrected?
Will Meneer Drichen adopts, moves for the adoption of the minutes, Chair?
Honorable Niveau Drichens moves for the adoption. Any seconder?
I second, Chair.
Honorable Jailer seconds. Anyone who objects to the adoption of the minutes? No one. The minutes are adopted as corrected. Let's go to the next set of minutes. Minutes of the Portfolio Committee on Justice and Correctional Services dated 6th May 2021. The minutes were circulated and taken as read. Any corrections on page 1? On page 2? On page 3? Is there a mover for the adoption of the minutes?
I move for adoption, Chair.
Honorable Jailer moves for the adoption of the minutes. Any seconder?
Second, Chair.
Honorable Mala seconds. Anyone objecting? And no one. The minutes are adopted. Let's go to the next set of minutes. Members, I think it will be the minutes of correctional services needs to be adopted at the subcommittee level. Well, I think it needs to deal with the heading. It's misleading, because I thought these were minutes of the subcommittee, but they seem not to be. Okay. A draft minutes of the Portfolio Committee on Justice and Correctional Services dated 7th May 2021. The minutes were circulated and are taken as read. Any corrections on page 1? Page 2. Page 3. Honorable Niveau Drichen.
Yes, Chair. Point 1. Okay. At point 1, bullet number 2, the new DG, Chair congratulated the new DG. There's no name there, so please can you add the DG's name, because it's not there.
Thank you very much, Honorable Niveau Drichen. Page 3. Page 4. Is there a mover for the adoption of the minutes with the addition?
Honorable Niveau Drichen moves for the adoption of the minutes, Chair.
Honorable Niveau Drichen moves. Any seconder?
I support a second, Chair.
Honorable Maseko Jailer seconds. Anyone who's objecting? Minutes are adopted. Let's move to the next set of minutes. Draft minutes of the Portfolio Committee on Justice and Correctional Services dated 11th May 2021. The minutes were circulated and are taken as read. Are there any corrections on page 1? On page 2. Is there any move for the adoption of the minutes?
Honorable Nieuw-Drugen moves for adoption, Chair.
Nieuw-Drugen moves for adoption. Any seconder?
Seconded, Chair.
Honorable Mala seconds. The minutes are adopted. Anyone who was objecting? The minutes are adopted. The second set of minutes, the next set of minutes. Thank you very much. Draft minutes of the Portfolio Committee on Justice and Correctional Services dated 12 May 2021. The minutes are taken as read. They were circulated and they're taken as read. Are there any corrections on page 1? On page 2, on page 3, is there anyone who moves for the adoption of the minutes?
Honorable Nieuw-Drugen moves for adoption, Chair.
Honorable Nieuw-Drugen move for the adoption of the minutes. Any second?
I second, Chair.
Honorable Jerry seconds. Thank you very much. Do we have another set of minutes?
No, Chair, we are done. We would go back to the report, Chair.
Thank you very much. Ms. Silkstone?
I've sent it here.
Okay. Thank you very much. Report of the Portfolio Committee on Justice and Correctional Services on the draft regulations submitted in terms of Section 92, subsection 2 of the Promotion of Access to Information Act 2000, Act number 2 of 2000, dated 14 May 2021. The regulations, the draft report was sent to members, was circulated to members, and it's taken as read. Are there any corrections on page 1? On page 2, is there anyone who moves for the adoption of the report?
Chair, I move for adoption.
Honorable Maseko Jele moves. Anyone who seconds? Anyone who seconds? Honorable members, are you not going to second this report? If you're not going to second it, then it will not be approved.
Honorable Chair, Honorable Nieuw-Drugen cannot second because she did not receive the report.
Can we have a 5 minutes break so that members can go to the report and apply themselves to the report so that we can process the report?
Sure, thanks.
Can we come back at 1:10? Thank you very much. Honorable Nivot Drachen, were you able to read the minutes?
Yes, Chair. I was able to read the report and I can second it.
Thank you very much. Any objections to the minutes, to the report, sorry?
The DA reserves its position, Chair.
The DA reserves its position. The report is adopted. Thank you very much, members, for your cooperation and assistance. But a word of sincere gratitude must go to the staff that have been working very hard during this period. It's a very difficult period for them. They have to deal with a lot of reports. It's a very big portfolio, this one, and they are working under extreme pressure, and they have done extremely well. We were able to do this work because they are the backbone of this committee. Thank you very much for your support and for your hard work, for your professionalism, and for your diligence. And to the members, also thank you very much for your commitment and your patriotism. It's highly appreciated. Honorable Breitenbach.
Thank you very much, Mr. Chair. I'd like to agree with what you have said about the staff. They consistently produce outstanding work, for which I remain extremely grateful. Thank you.
Thank you very much. Thank you very much. And to the ministry staff that is always with us, assisting also, thank you very much for your continued support, and to everybody and those that have been part of this committee watching at home, and also others who have continuously joined us on Zoom. Thank you very much. We will meet again on Tuesday. Please take this weekend to relax. The next 2 weeks are going to be very hectic, extremely hectic. Take whatever time during the breaks that we have to regain your strength so that we can come back to serve our people to the best of our ability. Thank you very much. The meeting is adjourned.
Thank you, Chairperson.